We should not be living in a United States of America where the Fourth Amendment against illegal search and seizure has been thrown in the trash can by the United States Supreme Court. Quite the opposite with Donald Trump's roving band of federal shock troops. We needed the Fourth Amendment at this moment. That's the exact moment that the Fourth Amendment was invented for, was created for. But to the United States Supreme Court, it's a mild inconvenience to be thrown to the ground off of racial profiling because of where you work, where you hang out, what language you speak, what accent you have, and what is the color of your skin, and what job you're performing. Those can all be part of the racial profiling of reasonable suspicion under the Fourth Amendment. We look to the United States Supreme Court to protect us, to be the firewall against an out-of-control president of the United States. But our pleas are apparently falling on deaf ears. On Legal AF, the podcast, we look into the new Fourth Amendment decision, the concurrence by Judge or Justice Kavanaugh, and the fiery dissent of Justice Sotomayor. And here's a clip. Let's kick it off with the Fourth Amendment, something that I'm sure is near and dear to your heart as a former prosecutor. The Fourth Amendment is in the Constitution for a reason. It protects us and provides an aspect of our civil liberties to be protected against illegal search and seizure at the hands of law enforcement, whatever that law enforcement is. Could be state, could be federal, whatever it is. ICE, Border Patrol, your local cop on the beat, FBI, you name it. If somebody's got a badge and a gun and they're trying to talk to you, stop you and talk to you, frisk you and talk to you, or in the case of Donald Trump's ICE and Border Patrol, hog tie you, throw you to the ground and zip tie you, and then ask you questions, then the Fourth Amendment is supposed to be implicated. That's what I was taught. That was the Fourth Amendment until yesterday or the day before, when off of a appeal by the Trump administration of a ruling by Judge Frimpong in California, of course, which is ground zero for the fight for our civil liberties right now, in Los Angeles. She ruled that there were certain aspects of a person or their location or their accent or their ethnicity that cannot be used as part of a reasonable suspicion. That's a term of art in the Fourth Amendment landscape developed by the Supreme Court over time. The reasonable suspicion that a law enforcement officer has to stop somebody based on the totality of the circumstances and based on a reasonably objective observer being that law enforcement cannot, according to Judge Frimpong, include what people look like, their race, the language they speak, the accent, where they hang out, or where they work. And it seemed reasonable to me. Oh, look, there's a brown person speaking Spanish in the Home Depot parking lot or the car wash or the field picking fruit, or I got to go over and ask them if they're a U.S. citizen. Like, no, or if they're a proper legal status. And now, in a one paragraph off the emergency shadow docket, a one paragraph with no explanation except for what Kavanaugh has to say in his concurrence, and of course Sotomayor in a fiery dissent, they just destroyed the Fourth Amendment. Talk to the audience about it from a former prosecutor standpoint, what it means, and then we can pick up with the battle between Kavanaugh and Sotomayor.
Yeah, so there's the Fourth Amendment to the United States Constitution. It reads, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or persons to be seized. That's what the Fourth Amendment says. And that has been interpreted throughout history by a gazillion courts. And they have essentially created this statutory or this legal framework, this framework that has been interpreting this to say that you can only stop people and seize them, search or seize them when you have probable cause. Now, that doesn't mean police can't also stop you and ask you questions or pat you down for their safety. That's what you need reasonable suspicion for. But even sooner than that, even like if a cop sees you on the street, they're allowed to just walk up and ask you a question. You don't have to answer them, but they can talk to you. But in order to be able to search someone or pat them down, you need reasonable suspicion. And again, if you want to detain them, you need probable cause, or if you want to completely search them, and et cetera. So that's the statutory framework and they define what these things are. And one thing that they all have in common is you're not allowed to make generalities. You're not allowed to say, oh, a Black person in the wrong neighborhood who looks a certain way, I'm just going to stop them. You can't just do that because of he's Black. You can't use certain protected categories, but you just can't make generalizations, broad generalizations, and especially when it comes to racial profiling. And that has been the law in the United States. That's how I've always understood it to be. And what this does is it completely guts that. It completely eviscerates it. It says, no, you don't have to make an individual determination about the individual person. You can just make these broad generalizations like they look Hispanic, they speak Spanish, they are in an area where Hispanic people go or congregate. They are in an area where there are low-wage jobs that are typically held by people who are immigrants. And so they essentially said that that's okay. Now that is what you can do. You no longer have to have an individualized basis to stop someone just because they're part of a certain group that you can now make these assumptions about. You can stop them. And frankly, if they don't have their papers and they can't prove that they're citizens, they're going to go and say, I now have probable cause to seize you and deport you, frankly. And this completely eviscerated the Fourth Amendment, this decision, without any guidance, without any specifics for lower court judges. What does this mean now for the body of Fourth Amendment law that we've all relied on in cases? I mean, this doesn't apply just to immigration. This Fourth Amendment law, I mean, who knows? A judge might interpret it that this is only for immigration, but they didn't give any guidance. And so what essentially this does is it allows people to say from going forward that, no, the Supreme Court says it's perfectly fine to use these racial stereotypes and generalizations to arrest people and or deport them or seize them. And that's what's going to be really, I think, challenging. And to do an emergency order like this on the shadow docket, you deprive lower court judges and lawyers the ability to know exactly what does this mean and how do you interpret this? And so it completely, as you said, eviscerates the Fourth Amendment. And I think people are going to have to start carrying around their passports and their papers, because otherwise, they risk being taken away from their family and deported. I mean, we know from Abrego Garcia that they make mistakes deporting people, and they're certainly sweeping up lots of people. There have been United States citizens who've been detained, and they just don't mind casting a wider net. So this is extremely troubling for everybody, I think, because of this decision. And one other thing I want to just point out is the hypocrisy, because this is the same court that has ruled that Harvard and all the universities are actually not allowed to look at race. You can't consider race. You can't take that into consideration, or ethnicity. But you know what? ICE officers or officers on the street, you can consider ethnicity and race. So it's just really ridiculous how they have different standards depending on if it suits their needs. So this is a very, very troubling decision, in my opinion.
Yeah, and Kavanaugh doesn't help matters any when he writes his 10 or 12 page concurrence, which is the only thing we have, since there is nothing to go on. As you said, and I said, there's a half a paragraph, literally half a paragraph, that put the Fourth Amendment out of the court's misery, apparently. Kavanaugh says, I don't know what world he lives in. He doesn't live on planet Earth, but he lives in a world where LA is just run amok with immigrants, criminal immigrants. And he doesn't think that the mere inconvenience of being stopped and asked a few questions, just simply asked a few polite questions from law enforcement, is any great thing. But it completely rejects and ignores the record developed by Judge Frimpong below. That's not what's happening in real life. What's happening in real life are these people who happen to have an accent, who don't speak English exclusively, which newsflash to Kavanaugh, even though he recites it in his order, there's no constitutional requirement that to be an American citizen or have legal status that you speak English. Even though he says, well, some of them don't even speak English. Like, okay. Is that Frimpong, and then Sotomayor picks it up in her dissent, says, no, that's not what's happening. What's happening is people are being dragged out of their places of work, gang tackled in parking lots for Home Depot or at car washes, thrown up against the wall, zip tied, having their arms twisted behind them. I mean, but to Kavanaugh, it's a one-liner. A few simple questions about your citizenship and then being let go is not an inconvenience, except that's not what's happening. And that's not the real world. But this MAGA Supreme Court has never let anything like stubborn facts get in the way of making a decision. In fact, they just make effect. We don't even, according to the MAGA on the Supreme Court, the alt-right wing of the Supreme Court, we don't even need cases from below. They just issue pronouncements and proclamations and fiat, and they say we don't want to get. I live with it. We don't want to get bogged down in the facts. You're an appellate court that is supposed to be reviewing the facts below and the record below, not ignoring it. In fact, if you're ignoring the facts, then there is no live case or controversy, and you're giving an advisory opinion. So Kavanaugh goes on to say, basically premised on what I just laid out, which is reasonable suspicion should be able to include those things in the totality of the circumstances, and it will unreasonably hamper the government to be able to chase after other human beings and determine whether they are citizens or not. I mean, you had an example in there from Sotomayor's fiery dissent, which says now, based on this announcement by the Supreme Court, what you look like, where you work, and how you sound can now lead to the violation of your civil liberties, and for you to be illegally searched and seized. And that should not be the America I respectfully dissent. She gives the example where one guy was born in America, he's a U.S. citizen, but he had a real ID, which is a way, I guess, to show you're a citizen, a real ID. But they asked him in the heat of gang tackling him, they asked him what hospital he was born in. Now, look, sitting here now, I can tell you, like over a cup of iced tea, I can tell you what hospital I was born in, but I'm not sure I'd be able to do that if I was like facing down the barrel of like armed agents and they're with my heart beating and racing and maybe not understanding everything that I'm being asked. And they took his real ID and then never gave it back to him. But like you said, or I said earlier, you got to have like what, birth certificates and passports hanging around your neck like dog chains at this point. And I would have thought this is not something, the Fourth Amendment is not something they would have handled on the emergency docket with an incomplete record, a short-circuited briefing schedule, no oral argument. But they always pat themselves on the back, like you see Amy Coney Barrett on her book tour right now to earn her $2 million advance, saying, well, we're only making a procedural ruling right now. There's going to be a full-blown appeal off the preliminary injunction that Judge Frimpong is doing. And we'll get the full record. And maybe down the road, ICE and Border Patrol are all geeked up off this ruling. Within seconds, they went back out and did raids in schools and factories and farms and parking lots and churches. I thought that's what the Supreme Court was supposed to do, be the last line of defense for our civil liberties and our civil rights. No, gone. So anything else on the Fourth Amendment, Karen?
No, I think we covered it.
Welcome back, Legal AF, the podcast. Top 50 in the world on Apple. Top 40 so far in YouTube weekly reports. It's all because of you. We appreciate it. Continue to help us grow. Stay here on Legal AF, the YouTube channel. Hit the free subscribe button as we make our march towards 800,000. We're only 5,500 short of 800,000 subscribers before our September 17th birthday. Now's the time to register your support for Legal AF and hit the subscribe button. Slide over to Legal AF Substack and do the exact same thing. You'll see amazing new content there, including live reports by me. Support the podcast. audio versions, video versions. We do it twice a week, Wednesdays and Saturdays at 8 p.m. Eastern Time on the Midas Touch Network. And then we put up commercial-free versions on Legal AF Substack. So until my next report, I'm Michael Popak. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.